And as Ben noted, both the and the broader statutory scheme show us that this provision was enacted to protect authenticity and not accuracy, and to insert an accuracy prong into the forgery law would unduly expand forgery beyond its intended scope. As the law stands right now, it is not clear what it means. It is a crucial component of statutory interpretation that no individual be forced to speculate at peril of indictment what it is that a law means. And that is what has happened here.
In order for your client to prevail, do we have to adopt your interpretation of false, or is there another, is there another argument on which your position hinges with respect to the interpretation of the statute?
I think to best illuminate what the legislature intended is to adopt our provision, our interpretation of the word false, because I think that the statute is designed to protect authenticity. It is situated in the criminal code right before the criminal simulation statute. They work in pari materia. They have similar goal, similar scope. Criminal simulation protects the authenticity of things, objects, antiquities, paintings, that nature. Forgery protects the authenticity of writings.
But doesn't the argument, I guess to me, it's very important how we interpret books or records in, I guess, really the whole phrase in books or records. I mean, on one view, the book or record could be sort of the entire kind of record of the Secretary of State's office related to, this collateral or this individual. And that, if that's the case, then the inauthentic or the false entry, which you interpret to be inauthentic entry, could be sort of this entire financing statement of marring the authenticity of the Secretary of State's record. So it seems to me that one could adopt your interpretation of false and still find that there was a forgery here, depending on the interpretation of books or records.
And I agree with you, Justice Campbell, that books or records is also not defined in this provision or more largely in the criminal code. As I will get to when I talk about value a little bit more, I would suggest that on these facts, in this case, that the answer to your question is pretty easy, because no one gets to really rely on the authenticity of filings in the financing statements in the Secretary of State's office. We have case law which demonstrates that those financing statements serve a purpose to provide sufficient notice so that third parties can more completely investigate what they actually mean.
But doesn't it signify, though, that if somebody files a UCC-1, it signifies that they believe they have a real claim as to this collateral. It signifies to the world that this person is asserting a real claim as to this collateral. But here you have the additional element, though, the intent element, that they put false information into a financial statement with intent to harm. And it actually does do harm sometimes, doesn't it?
It does do harm, and it was criminalized by the legislature in 2012, and then they looked at it again in 2013. The law that has already been recited here, 39-17-117.
But that statute doesn't actually require intent to harm, does it?
Intent to encumber, I believe, is the language in that statute, where there's no unauthorized or legal base. Where there is no authorized reasonable basis or legal claim. The financing statement standing alone, however, only indicates the possible existence of some kind of underlying claim. It is merely a notice document. And in fact, this is a good opportunity, I would think, to delve.
But these are not even possible, are they?
But third parties rely on those oftentimes for financing decisions and everything else.
They rely on them, but they also have a duty to investigate further to clarify the exact nature of the relationship between the secured party and the alleged debtor. the notice filing laws in our state and in the UCC nationally have become more and more simple over time because of a specific policy goal of making financing statements and notice of the possible existence of this claim as simple as possible. A financing statement includes and requires very little information. It is described as skeletal. Sure, it requires authorized information. And in fact, when someone goes to file a financing statement, they are put on notice. It's one of the first 2 or 3 computer screens that a filer encounters is notice that an unauthorized financing statement, an unauthorized filing will break the law 39-17117, Class C felony. They are not put on notice that it may be a perjured or forged filing. But yes, it should be, it must be authorized to meet with the law, of course, Justice Bivens. But these are very simple documents. They are designed to have as little information as possible, reducing transaction costs for secured parties and putting the duty on the world, the third party creditors, the next in line in a queue of potential creditors to look behind the financing statement and see what the terms of an underlying security agreement actually are.
Would you say that under, because the statute is section 3911-106A39, this is kind of the definition of
value definition.
Right. Would you say that a financing statement is a document constituting evidence of a debt within the meaning of that provision?
I think that on the one hand, under looking at what it is, yes, we can very reasonably see it that way. Part of our revenue laws, the recording tax statute, expressly calls a financing statement a document evidencing a debt. Yes, Your Honor.
But as a practical matter, another creditor or anybody seeing that financing statement is not going to ignore it. I mean, say they have an obligation to investigate, but in the real world, they just, someone may look at that and think, well, this is inappropriate. This was obviously made up. This judge doesn't owe this person $13 million or whatever, whatever it is. They can't just ignore it. I mean, to do so would be at their own peril. And that's I guess why the statute was passed.
Absolutely, Your Honor. And it does cause problems for both the people named as alleged debtors and anybody, yes, who's looking to determine if a given collateral is already tied up with some debt. That is exactly why the legislature met twice in 2 sequential years to hammer out a solution to unauthorized filings.
But to Justice Bivens' point earlier, why could somebody not be prosecuted under either statute, either the one that you just referred to that the legislature specifically crafted to address this, or the forgery statute, which requires a higher level of intent, has different elements?
I don't think that there's any reason, if it meets, of course, if it meets the elements, that they couldn't be prosecuted under both. Okay. I think in my briefing, I noted the existence of the unauthorized filing statute in many locations to help as an interpretive tool for the legislature, the intent of the legislature as to both provisions. Forgery is a law that means one thing and no more. As with every law, it has to have a boundary to it. It has to have some reasonable cordon. The same with the unauthorized financing statement or unauthorized filing of a financing statement. Those laws have coordinates, they must. And part of this court's job will be to interpret what the cordon of forgery is and if it includes the conduct here. If it does, of course, I don't think there's any basis for saying they couldn't be prosecuted under both. I think
I think Mr. Russ indicated you were going to address the valuation.
Could you
address that for us, please? Yes.
My primary position on value is that under the law and under the policy of the UCC, these are mere notice documents. They do not create a legal relationship. There has to be an underlying security agreement to do that. They are not, in fact, liens. The lien is the underlying security agreement. These are simply notice filings. They are simple and skeletal instruments by design that serve one function, as Justice Kirby noted in 2011, writing for the Court of Appeals in the case of Regents Bank versus Brick Contractors LLC. Quote, the purpose of a financing statement is simply to provide sufficient notice to third parties to instigate further inquiry. Standing alone, unquote, they confer no rights. They function merely as a heads up, look, this debt might exist. In this way, they are more akin to a save the date card than the wedding invitation, a bookmark than the book, a shopping list than the actual sales receipt, which
but even if it's a document, so you seem to agree that it is a document constituting evidence of a debt within the meaning of the valuation definition. So if that's the case, then isn't it really a factual question as to what the value of the debt is that the document is evidencing?
I think that there are two questions that are questions of law when we look at value of these documents. The first is, does it have any value at all? Is there value? My main contention about these documents is that they have no ascertainable value. The second question that I believe is a question of law is, if it has a value, how is that value determined? Once those two questions of law are answered, I think a jury can decide what the value is based on the legal guidance of if and how.
But if the person filing the document lists the value that they claim to be encumbering, isn't that at least some evidence that can be submitted to the jury and let the jury decide whether it's sufficient or not to set a value that would meet the threshold of whatever felony it is?
Yes, Your Honor. I would like to make a very, very pertinent point here, though, is that a financing statement does not proclaim value through the words written in the collateral description. The collateral description does not define value of this instrument. Collateral, as we know, is simply the property that secures the debt. If this is a document evidencing an indebtedness, then 39-11-106 tells us that we have to look at the size of the loan. The collateral description is not the size of the loan. The size of the loan is best reflected, if this court looks at it that way, in the principal maximum indebtedness line item, which in every single instrument filed in this case read $0.00. Collateral belongs to the debtor, and any value of this instrument would be defined as the size of the debt, not the collateral. Mr. Nathan Burton, a trial witness for this.
You're into your rebuttal time.
I will stop there. Thank you.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the defendant's convictions for forgery because the evidence presented at trial was sufficient to establish their guilt. In their briefs, the defendant have collectively raised 7 different challenges to the sufficiency of the evidence. I've noted that I believe 5 of them have been raised here. And so for the remaining 2 regarding the factual determinations of identity and intent to defraud or harm, unless this court has any questions, the state will rely on its brief for those issues. Turning to what I think the first issue that was raised deals with this definition of false and sort of this distinction between a false entry and a false making. And I think, Justice Campbell, you made sort of the penultimate point, which is we don't look at just the word false. We look at the entirety of that sentence, which is a false entry. And when you look at that, especially in combination with subsection B1A, which incorporates sort of the traditional definition of forgery, which is in fact a false making, that when the legislature used the terms false entry, it indicated that they were focusing not on the authenticity of the document, but instead on the accuracy of the information therein. And so under section B1B, which deals with a false entry into a book or record, the question is, was the information that was placed into that book or record accurate or false?
Well, let me ask you this. It's kind of a similar hypothetical, but many years ago, I used to do title searches. If I went and found a mortgage a deed of trust on a property. And then a year later, there was entered a release of that deed of trust by vice president of a bank, okay? But let's say the vice president of the bank was corrupt and the loan was still out there. He just entered that document. Are you saying that's a forgery?
Under subsection B1B, if that's false information that is entered into the record that you looked up, and the other additional element that Justice Kirby pointed out is that that was made with the intent to defraud or harm, then that would constitute forgery. Yes, Your Honor.
So what is the record in this case? Because I'll just tell you what I'm having trouble with. I'm having trouble with the phrase in a book or records, because I think in has to be given some meaning. And that to me suggests that the record at issue has to pre-exist. There has to be something inauthentic or false, inaccurate entered into a record that renders that record inauthentic. So what is I guess tell me both, what is the false entry here and what is the record into which the false entry is made?
Yes, Your Honor. So the false entry is the false information contained in the UCC financing statement, each one that was filed by the various defendants. The record at issue here are the records of the Office of the Secretary of State of Tennessee. Mr. Burton testified that he was the custodian of those records, that those are the records people search when they're looking up someone or things of that nature, and that when you look that up, those records are what put the world on notice of a potential property interest. So the record in this case would be the records of the Secretary of State of Tennessee.
How broadly are you construing records? I guess, what's your definition of records? Does it include all public records? Anything that could be considered a record for purposes of the Public Records Act?
I think based on the plain language of the statute, anything that constitutes sort of a public record, or additionally, when we're talking about books, I think that is where sort of books of accounts come into play. And
for private entities.
For private entities in that nature. And so it's important to note that the plain language would incorporate the records of the Secretary of State's office, and the defendant instead attempts to rely on the legislative history of the forgery statute and the other statutes that were sort of incorporated into the forgery statute in 1989. But I think, Justice Bivens, you made an excellent point that sort of is the downfall of the defendant's argument, which is those prior statutes, and I'll highlight the informations, referenced books or records of an employer or books and records of any depositor or customer. And when the legislature incorporated that language into the forgery statute, it did not, and we have to presume that it intentionally did not include those words. And so instead, the legislature made it more broad to incorporate all books and all records.
So if a person fills out a loan application and overstates his or her income or assets, that for the purpose of obtaining a loan, forgery?
I'm not entirely sure.
Because that would be a false entry, and it would be in a book or record, say, retained by the bank.
And so to Justice Campbell's point, I think records can at least be limited to sort of public records, and that's
so if it's a private, so it has to be you say it has to be a public. How do we get that out of this statute? It has to be a public record.
And so I think it can be. I think that your hypothesis could constitute a forgery.
Do you know of any forgery cases made on those set of facts?
Not that I'm aware of, and until this case, I wasn't aware of any forgery cases that were tried with this. But that goes down to prosecutorial discretion and sort of the local district attorney's discretion on what to charge and how to prosecute these types of matters.
If the forgery statute applies here and it carries a significant penalty, why would the legislature enact the False Lien Act with a lesser penalty aimed at the same conduct?
So sometimes it's aimed at the same conduct. And I think this goes to Justice Page's question about whether this is the same conduct. And I'd like to point out that there are different elements in these offenses. Justice Kirby sort of highlighted the most important one, which is that forgery requires the intent to harm or defraud, whereas fraudulently filing a lien simply requires the defendant to know that there's no legal basis for placing that lien. And I think the easiest example would be to highlight one of the arguments that is made by several of these defendants, which is that they did not have the intent to harm or defraud. And so were a jury to believe that defense, then a defendant simply could not be convicted of forgery. But if the jury believed that you didn't mean to harm them, but you knew you had no legal basis to file this lien, you would be convicted of fraudulently filing a lien. And I think sort of vice versa, you could convict someone of forgery and not fraudulently filing a lien when they have a valid basis and they simply misstate that. So if there is a legitimate loan that is given and someone has a legal basis to file a financing statement establishing that they have that security interest, but the loan was for $5 and they put in their UCC financing statement that it was millions of dollars specifically with the intent to harm or defraud, well, they had a legal basis to file that lien, but they put false information in it. So that's forgery, but not fraudulently filing.
What was the proof of intent here to defraud or harm?
I think that a little bit goes towards the valuation or the money that was listed in the collateral. And I think really the testimony that highlighted that was Mr. Birdsell's testimony, where he was expressing his frustrations over a speeding ticket and was told, well, that's $4 million. You're going to get that just because. And then Mr. Birdsell didn't just file it against the officer who wrote him a speeding ticket. He started filing liens against everyone. And so the jury could, from that information, could rationally determine that the defendants had the intent to harm or defraud these victims because they felt wronged by them. And
Mr. Coleman, why isn't the fact that the legislature used records in conjunction with books, so books or records, the phrase, some evidence that it intended a narrower meaning of records? I mean, that phrase is often used. Those words are often used in tandem, books or records, to sort of signify, books of accounts or records of accounts, the official records of some entity. I mean, isn't that, to me, that suggests that records maybe isn't as broad as you are construing it.
And I think that would be the case if it weren't for sort of the plain language of what a record can constitute more than just a book of accounts. And two, the legislative history of how we got here, which is that the legislature, and we presume that they did this intentionally, specifically excluded the language of books or records of an employer or books and records of a depositor or customer. And so when you have those secondary clauses, they kind of limit what books or records constitute. And when the legislature got rid of that, they expanded the definition. We have to, again, presume that they did that intentionally. And so, again, to briefly cover those sort of three arguments, is that a false entry is different than a false making, and the legislature used the terms false entry when dealing with section B1B. A book or record is the legislature intentionally expanded that, and certainly the records of the Secretary of State's office, which are public and which multiple people rely on all the time, are valid records under the meaning of this statute. And then again, these separate offenses, while they sort of overlap in a Venn diagram in this situation, the offenses of fraudulently filing a lien and forgery have unique elements, and individuals can commit one and not the other. They just happened here to meet the elements of both. Briefly, before I turn to valuation, there was a mention of these liens being rejected. And I just wanted to be very clear that the testimony and even from the face of the financing statements, these liens were all filed. Several of them were later terminated, but Mr. Burton was very clear in his testimony of how that worked, where they were automatically filed. And then the individual who was the alleged debtor had to file a letter contesting that claim. And then if the Secretary of State did not get an answer from the filer, they would later terminate it. But for that duration of several months, those liens were filed. And lastly, if the court has no other questions, I'll turn to valuation. And I think sort of the, again, penultimate point here is that the defendant concedes, to your question, Justice Campbell, the defendant concedes that a UCC financing statement is a document evidencing indebtedness. And so really that becomes a question for the jury of what is the represented debt here. And really there are only two numbers on the UCC financing statement, and that is the number listed under the maximum principal indebtedness, which the defendants are asking this court to find, and then the number listed in the collateral. And here, as a matter of law, the maximum principal indebtedness cannot be used for anything other than tax purposes. It cannot, as a matter of law, be used to establish the represented debt here. And as Mr. Burton testified, that's not how it's used. What people look at when they research a person's name and come upon a financing statement is the interest in whatever type of collateral is listed. Specifically, it puts the world on notice that the filers have an interest in whatever type of collateral is listed. And that's the direct testimony. And here, when the collateral is listed very clearly in dollar amounts, any rational trier of fact could easily conclude that the value of the represented debt by this statement is the millions of dollars listed in the collateral.
Well, why? So that's where you lose me a little bit, because to the extent this is evidence of anything, it's evidence of a debt, but the collateral is not the debt. The collateral is I guess the strongest part of your argument, as I see it, is that the jury could infer from the value of the collateral what the value of the debt might be, even if the amount of the debt is not listed. Is that your position, or is your position that the value of the collateral itself is the value at issue here?
I think our position is that the jury could infer from the collateral that that was the amount of the alleged debt. There was no debt here. And so there is no actual debt. And the question is, what does this financing statement represent?
Right, but when we're talking about forgery, it's always something, it's never going to be real. But you still have to sort of value it. If there's a check written for, a forged check written for $100, that's not $100, but you would value that at $100, right? And so there's no debt here. But if we need to attach a value to this, what is the value that we're to attach? Is it the collateral, or is it just an inference from the amount of collateral as to what the underlying debt could be?
I think here they're one and the same, Your Honor, specifically because the collateral description in these financing statements use specific dollar amounts. And so generally, or what could potentially happen when someone files a financing statement for loaning a business money to pay employees or something, is that it will be, all principals and assets of that business. And if that was sort of the collateral description, then there's no way to determine what the debt is without further proof. So
why isn't it just not ascertainable?
Because here they use dollar amounts. And I think even in the situation where they listed assets and things of that nature with the business, you could still prove what that collateral is or what that debt is based on testimony of what the loan was or what that collateral is valued at. And so here we just don't need that because, again, the collateral description listed millions of dollars, and it just in boldface, 9-digit numbers, $4 million, $6 million. And from that, it's a reasonable assertion or a reasonable inference for the jury to make that was the actual debt, or that at a minimum, the debt represented by that was more than $250,000.
Those amounts might show the value of the debt, but the statute references the value of the property or services obtained. What property or services were obtained here?
So the represented debt is the property would be the money allegedly owed by the victims. And so we have some testimony from some of the victims that this impacted them because the value represented by these financing statements caused them hardships, prevented them from buying or selling a house. It required an increase.
You can understand there was harm, fully understand that, but trying to work this theft statute into this particular factual situation, I'm having trouble understanding how to make this language in that theft statute work. If the value of the property or services obtained is X dollars, because there were no services or property obtained here. That because we're trying to fit a square peg into a round hole here?
I think so, Your Honor, but not just here, but generally sort of in forgery when there were no services or property obtained because hopefully they were caught. Well, then if there's nothing obtained, you still have to question what the value is. And so generally when it comes to forgery, the value is based on the evidence of indebtedness or the represented debt that forgery proclaims to the world.
And looking at the theft statute, so it says, and so if we're talking about a document, if we're trying to value a document, so the value of a document is if it's a document constituting evidence of a debt, which the defendant seemed to concede this is, it's the amount due and collectible at maturity, less any part that has been satisfied. And so that to me, I think we have to get at what I know there's no debt here, but it's not the amount owed. if there's if there is an underlying, security agreement, then the amount owed is not the amount of the collateral. I mean, it could be if the value of the loan equaled the amount of the collateral, but most of the time it's not necessarily going to be the amount of the collateral. It's going to be something different. And isn't that, I mean, under the statute, isn't that what the value is the amount of the debt?
I think you're right, Your Honor. But here, again, where the collateral specifically lists out a very particular numerical value of dollars, that is a representation of the debt. And anyone who looks up an individual where one of these financing statements were filed against them will determine that, if this person were to go bankrupt, they owe the filer millions of dollars. That is the amount due and collectible at that time. And so, again, you have this sort of wonky situation where forgeries don't have any actual debt, but what they represent is what the value is. They're evidence of indebtedness, and this, these millions and millions of dollars listed, and again, bold-faced numbers, are sufficient for a jury to make a factual determination that that was the amount of the loan or the debt that was being alleged, and to use the specific language, that's the amount due and collectible were it to be sort of banked in or cashed in. So again, because all of the statutory elements have been met, the proof showed that the defendants were the ones who did this, that they had the intent to defraud or harm, that they made a false entry, that false entry was placed into the records of the Secretary of State's office, so it was into a book or record, and that the valuation was at least $250,000. The state submits that the evidence presented at trial was sufficient to support the convictions for forgery, and we ask this court to affirm those convictions. And no further questions. Thank you.
As I know I don't have very much time for rebuttal, so I'll try to make these points brief. What I heard the state argue, I believe, in answer to Justice Bivens' question about the construction of Section B1B of the statute, well, if we're stuck with the language, we're stuck with the language. But if we're going to look at a legislative intent, then we'd have to look at legislative history. I think the legislative history supports our points that this is a document that requires to be falsely made. I can't recall who asked, but okay, so why is this a public record? There's nothing that limits it if we're limited to the language of the statute. It could be any record. My example of falsifying my child's absence slip would, there's nothing that says it must be a public record. So I think there's problems either way with the state's argument. Justice Kirby, you were asking what's the difference between the fraudulent lien statute and this, and saying the intent to defraud. Well, a fraudulent lien, one, I can't conceive of a reason you would file a fraudulent lien that wouldn't have the intent to harm. And second, fraud is in the title of the code section. So fraud is required in that as well. So I again would say, I don't know why the legislature would enact a separate statute. It is permissible, but it doesn't make very much sense if forgery already covered this conduct. Lastly, Justice Campbell, you I think are arriving at the same point that we're talking about with this, the idea that in the book or record, it must be pre-existing. I would say that that is akin to what I'm trying to argue, that the entire set of books or records are then falsely made by the doctoring of the records. And that's why it is in reference to, in my opinion, a set of accounts. And again, yes, the words book or record put in that phraseology generally means that.
Would you acknowledge that there could be a situation where a document is, I guess it's from who it purports to be from, right? So I guess maybe this is Chief Justice Page's example where, it's a bank releasing a mortgage, and it's from the bank. So there's, it's not the bank purporting to be someone else, but, they're putting this in the file. Wouldn't that render the record, like the property record itself inauthentic? Would you say that that would fall within the definition of forgery? Or does it have to be
Well,
a false
I mean,
entry? Does it have to be kind of a doctoring of an entry in
I would say no,
a
because
pre-existing record?
again, for the example, I think what Justice Page had said is once that release is sent to the Register of Deeds office, is that a forgery? And the answer would, again, I think be no, because you're relying on a third party to essentially create the forgery by the filing or entry into the book of record. I'm not sure if that answers the question you were asking, but I think that it does.
So it would be your position that if a third party is involved at all, if someone has to put the document in the record, then it's not a forgery.
Well, I think it would be outside the scope of any other type of forgery that's prescribed here. And again, I think it's an argument that doesn't hold water, that the legislature has made subsection B different than A. There's nothing in subsection A that defines false making either. So including the term false and then somehow extrapolating that it doesn't mean a false making is tilting at windmills, I think. So
Thank you.
I'm over time.
Thank you. Ms. Tennant.
Thank you. To go back to what this type of document is, looking at value, I think it can be considered a document evidencing a debt under 3911-106 A39B, which looks at the value of documents. I think it can also be considered an item for which no value can be ascertained, and that falls under 3911-106 A39C. That was actually charged to the jury in this case. The document definition was not. The jury never heard that they could be looking at the value of the debt. I'm saying that because these are our laws and questions of law, that's where this court may end up, calling this a document evidencing a debt. But I think the much more reasonable characterization of a financing statement is as a mere skeletal notice document that is not a lien, that does not create a relationship, that does not really do anything other than say, hey, look, a debt may exist. It is most reasonably construed under subsection C of the definition of value, which is something for which no value can be ascertained. And as such, it would be deemed to be worth less than $50. And that was charged to the jury in the jury instructions.
Thank you.
Wow.
And with nothing further, I would ask this court to consider that calling a financing statement something that proclaims a specific value through its collateral description would invite a lot of confusion in the world of the Uniform Commercial Code. That is not how these documents are looked at. And I would say that that would be confusing to a lot of litigants out there. Suddenly, this document had a hard and fast value proclaimed through its collateral description. Thank you.
Thank you. All right, that concludes the morning session. We'll recess until 1 o'clock.
All rise.
All rise. Did they just raise the dead just now? Wake the dead, wake the dead. Okay, there it is.